So my name is John Giles, and I am the managing attorney at Michalsons. And really, I've been helping organizations to comply with complex data protection laws in a practical and effective way for many years now, about 15 years. And it's always nice to apply that knowledge to a particular group of people. And in this case, it's legal practitioners. And then we've got with us Mark Hank. Mark doesn't really need any introduction. He's been one of the pioneers on IT and data protection law in South Africa for many, many years. Mark was actually my principal when I was a candidate attorney, so everything I know, I learned from him. And Mark's also been very integral in the drafting and the formulation of data protection law in a South African context. And he's also done a lot of work with the Law Society of South Africa in producing guidelines for legal practitioners and attorneys, and done quite a few presentations as well on both POPIA and on data protection. So Mark, it's great to have you with us.
Thanks, John. Nice to be here.
And then we've got Michelle Davin, who's one of our attorneys. And Michelle focuses also on data protection and also helps legal practices to do what's necessary to comply. And it's great to have you with us, Michelle.
Good morning, everyone. Thanks, John.
Great. And then we've got Shamar Sheikh. Shamar is also one of our attorneys, and Shamar is going to be helping us today and answer some of your questions. We really do welcome questions, and please do ask them. There's functionality both under the Q&A and in the chat box. You're welcome to put them in either, but the Q&A is probably better because it enables you to vote up questions, so we can get the questions that are more important if you can vote for which ones you would like answered. So Shamar, very nice to have you with us.
Thanks, John. Lovely to be here.
Great. So I see a few more people have arrived, which is fantastic. There are a few people from Michalsons. There's also the Michalsons practice managers joined us, which is nerve-wracking because Michalsons has to comply as well as a legal practice. So it's nice to have and see who's here. Yeah, so in terms of an agenda for today, we've got an hour, and we thought we would do this more as a discussion rather than a presentation. It'll be fantastic to get the various people that are here as input and also to answer some questions. So we're going to follow a particular format for about 40 minutes, and I'll explain what that is just now. And then we'll leave about 15 minutes at the end for some questions and answers, but we'll try and answer your questions as well as we go. But as I said, please feel free to ask your questions at any point, and we'll try and build it into the presentation and then also build it into the Q&A at the end. I'm going to share my screen now and just show you a couple of things that we'll be looking at. The first is this is our presentation for data protection, and we use an analogy of growing a tree to demonstrate what you need to do to comply. And it's different for different organizations, so the tree is always different for different people. Legal practitioners have to do very different things to a bank, for example, very, very different things. And the steps that we believe you need to follow are, firstly, in terms of an introduction, there's some key things to talk about. Then you need to learn more, raise your awareness, then plan what you're going to do, then actually implement various things or take action to protect it, protect personal information, and then sustain personal information. So that's really what we're going to be, the discussion is going to be following that path through those steps. And we're really discussing this lens, which is a lens to the Michalsons data protection program. This is available on our website, and yeah, is really talking about who this presentation's for, who it's not. And maybe Shamar, you can pop a link to that in the chat box in case anyone wants to have a look at that. And then this is the actual lens that we have in our program. And this is really what we're going to be talking to today. It's, if you like, the written version of today's presentation. And we will share the PDF of this page with you. We'll also share a recording from today's session with you. So don't worry too much to take notes. This is a significant topic. We can't cover it in an hour. So we're not going to be going through every aspect of this written lens. We're more going to be discussing different components of it and showing you really important things that are important to look at. So that's really the agenda for today. I think what I'm going to do now is I'd like to find out a little bit more about you as the audience. And I'm going to ask you to have some quick fingers here because we've got about 8 polls and I'd like to really get a feel for who's here. So if you wouldn't mind answering these questions, let's go through them and get an idea of you as the audience. So the first one is, what type of legal practitioner are you? Are you an attorney, an advocate, a conveyancer, notary, practice manager, in-house legal? Let's get an idea of what role you perform. This is for legal practitioners in all different forms. Great, I see we're at about 65% voted. Okay, let's end it there and I'll quickly share the results with you. So interestingly, we mainly in-house legal or corporate legal. Quite a few attorneys, some advocates, and that's interesting. If you, for those who said other, if you wouldn't mind popping that in the chat, I'd be interested to know what I missed out. So yeah, if you in-house legal or corporate legal, certainly a lot of content today will apply to your in-house practice, but it is really, the content is really geared more towards private practice, but it still will apply to you as well. All right, then let's go to the next one. And I'm interested in, what is the size of your practice? If you wouldn't mind answering that. So I guess this applies to in-house as well. How big is your in-house team? Is it, yeah, how big is your in-house team would be interesting as well. I'm not getting answers coming through. I don't know, Michelle, can you see if there are any answers coming through? Yeah,
my side, John. Yeah.
There's a problem with it. So let me try, if you give me a sec. Let's try that. Hopefully that would work now. Let's see if, there we go. Yep.
Yeah, there have been some reports of errors when trying to answer their polls.
Okay, thanks, Jamal. Okay, great. If at the moment I'll share the results with you, but we've got a smattering actually, which is interesting. It's virtually evenly split across all of that, which is interesting. But so many of you, the majority of you are less than 10 people, and that means most of you are small practices. But let me share those results with you quickly. So as you can see, it's spread across, but many of you are small. Today is more geared towards smaller practices, but many of the things we say will apply as well to larger practices, but there will be more than that you need to do if you're a larger practice. So let's quickly have a look here at the question is, what outcome are you wanting to achieve from this session? So I see many of you are marking, I'd like to get an overview of data protection law, and this is multiple choice, so you can choose many of them. We're not going to give you an overview of data protection law in this session. There are resources on the Michalsons website that can do that. And Shamar, maybe if you can copy in the link to the page of Pop Here is Here Now What, and
Yes.
particularly the page on the overview. It's there's just too much to discuss and too much to cover in one go. But most of you are saying you'd like to know what the important things are for your practice, and that's certainly what we're going to achieve. We're going to give you some quick wins that are really important. And then about half of you are saying you'd like to raise your knowledge so you can advise your clients. And I'm afraid that's also not really the outcome or the purpose of today's session. This isn't going to help you do that. This is specifically trying to help legal practitioners to comply with the law in their legal practice. All right, so that's in terms of outcomes. We're almost done, but this is really important so that we know the audience. And so if you wouldn't mind marking off here, what is your focus area as a legal practice? And very much property and wills and estates are probably, and family, I would say, are the most impacted focus areas. And that's why they're at the top of the list. But it would really be good to get an idea of what you focus on. It's also multiple choice, so you can do many different ones of those. So great, thanks, you're doing well, it's looking good. Yeah, so let's end that poll and share those results. So you spread across many different focus areas. Yeah, but lots of you are property, wills and estates, and family, and that makes sense. Okay, great.
John, I see that from the chat, we also have some compliance officers joining and some legal advisors as well.
Yes. Perfect. And Quinton, thanks for that comment that you made about professional legal advisor being defined in POP here. It is very interesting. And what's interesting about it is that privilege only applies between a professional legal advisor and the client in a POP here context. And this is one of the reasons why we've said repeatedly that a law firm should be the lead in a data protection program, because you then get privilege. And it's something not many people know, but you can imagine a consultant does a gap analysis for a company on data protection, and then the regulator comes along and says, well, hand over the gap analysis. And the consultant would have to do that, versus a professional legal advisor wouldn't have to. They could be able to claim privilege relating to that document. All right, so let's go then to, let's get an idea of what you've already done. So how much have you already done to comply? Great, I see some more people have joined us, which is fantastic. I see some familiar names there, which is also great. I also see there's some members from our data protection program, which is fantastic. And let's share those results quickly. So most people saying I've done some things, but I still have much to do. And there's some that are really starting off. So we're almost done with the polls, but it really is very useful for pitching the content. So the second to last one is, which country are you in? It obviously makes quite a big difference which jurisdiction you're in, and you could practice in multiple jurisdictions as well. So it would be really interesting to get an idea there of that answer. Okay, I think the results there are in, so let's end that poll and share the results. So you, almost all of you are South African, so we'll do it from that basis. And then the last one is, how aware are you of data protection? I'd like to just get an idea of how much you know about it. So I see Shamar's posted the link in the chat box about POP here is here, now what? If you're saying I don't know much about it, then that's the place to start. There we answer 5 questions, and we go through those 5 steps. There are 5 recorded webinars of about 40 minutes each, and through that process, you'll learn a lot about it. But most of you are saying that you've got high-level awareness. Lots are saying you know just enough to be dangerous. But thanks very much. That's great. All right, so let's leave the polls there and let's kick off. And I think let's go, I'm going to share my screen and let's go across here to the introduction. So the first thing I wanted to talk about really is just why data protection is important. I think many of you know this. It's about protecting people from harm. But as legal practitioners, we process lots of personal information. And the things we do and the information we have definitely has the potential to cause harm to people. And so it's very important for us. And I don't think I need to stress that. I think everyone will know that. We need to balance various information rights. And again, I'm not going to tackle this in a lot of detail. Most legal practitioners are trained in balancing information rights, so I don't need to tackle that. But this is a very important point, is that you need to know what you're trying to comply with. And for legal practitioners, it's a combination of data protection laws. So in our case, and if you look at various different countries, well, most of you are from South Africa, so it would be POPIA. That's the law from a data protection perspective that you need to comply with. But the trick here is that there are other laws you need to comply with, and those include the Legal Practice Act. There's the code, the Legal Practitioners Code. There are many legal practice laws that apply. And the key thing to be aware of is that where there's an overlap, it's whichever law gives the data subject the most protection that's going to apply. So it's not just a case of POPIA. The rules and the code in the South African context both contain provisions around confidentiality and around information security. So very quickly, that's an important thing to look at there. The other thing to mention here in terms of a compliance strategy is that we all need to be aiming for absolute compliance, because legal practitioners will be held to a higher standard than other people. And so that's really important. But Mark, maybe if I can go to you, any other introductory comments that you think are important to share?
Thank you, John. I think that it is important to recognize that there are, we've seen quite a lot of cybercrime that has occurred. And one of the targets, of course, attorneys' practices. There was the famous bank robber, William Booth, who was asked once why he robbed banks. And he looked at the interviewer in a rather astonished way, and he said, well, that's where the money is. But just remember, because money is online these days, that's where it is as well. And the raw material for many of these crimes is personal information. So the protection of personal information is a critical thing. And I think that we owe it to ourselves, not only from the point of view of our own professional duties of client confidentiality, but from the point of view of looking after ourselves and making sure that the information entrusted to us is properly protected, and recognizing that many of us are doing things very differently to what we did even a while ago. I mean, just the pandemic has changed the way that a lot of practices will work, both now and in the future. And I think that that's a very important aspect of what we need to look at, is to be aware that these changes mean that we will need to look at different manners of managing the risk of the information that we process. And as John said, we process a lot of sensitive information. Our clients give it to us, and John mentioned privilege, for instance. One of the things that is germane to our profession is the fact that we have attorney and client privilege, and that privilege must be protected. If somebody gets your information, the privilege is broken, even if that is illegal, etc. But the privilege gets broken. So the protection of personal information is a critical aspect of any legal practice. Thanks, John.
Yeah, Mark, just to pick up on what you said, as legal practitioners, we obviously know about confidentiality and privilege. They're concepts we've been applying for years and years and years, not just related to personal information, but related to all kinds of information. So these concepts aren't new to us, and it's it's important to bear in mind that sometimes privilege actually and our confidentiality obligations are greater than what data protection law requires. And let's go to Michelle. Any introductory comments from you, Michelle?
I think it's interesting because, as Mark mentioned, with regards to cybersecurity and people going more technological and more on e-platforms with regards to like where they store the information or how they work. I think I worked at a civil litigation firm when I did my articles, and I visited the firm a while back, and it's just, interestingly enough, as opposed to what Mark mentioned, many law firms do still use, their records are mostly still paper-based. And I think many people have a misconception that because it is paper-based, maybe data protection in that sense doesn't apply to them. But there are many things that you have to do when, when your documents are paper-based. With regard to like storage in a locked cabinet where only limited people have access to, or shredding. I think if you have an HR department or someone in HR, you can't have CVs lying around of prospects or even your employees. So those are just things that some law firms that still do paper-based work just must be mindful of.
Yeah, great point, Michelle. I mean, just a quick story. I went to our local shopping center, and there's an attorney there who practices, I think he's a sole practitioner. And I went there to get a document commissioned, and I knocked on his door, and he sort of said, come in, and I could see him through the glass window. And he was sitting at a desk with a computer in front of him with files just piled around him, literally surrounded by personal information. And he was a conveyancer, he does family law, he's got a general practice. And he was sort of staring into the distance with a very blank look on his face and shame. I spoke to him and he said his secretary had just left and resigned, and he was trying to grapple with how to work with everything. And I think for me, that's part of what many legal practitioners feel like. They're very busy people. There's so much going on. They're dealing with their client work. This is now a compliance issue that they have to tackle. But it is an important issue. As Mark said, it's a really important issue for us. And it's something that we need to get right. And it depends on your type of legal practice, but many legal practices have a lot of paper, and you've got to keep that paper secure. We'll talk a bit more about that later. All right, great. So let's move then on to the next stage, and what the next step is looking at awareness. So it's to learn more about data protection. And as I said, we've got the 4 recorded webinars. You can look at those, but just to touch on a few things. The first is that the POP year deadline was 1 July 2021. So the grace period is gone. We're into full in effect mode. And so there's no time to lose, really no time, we're late. And then from an overview, what I thought we could tackle is to really try and give you an overview of data protection law and how it applies to legal practices in about 5 minutes, which is really tough, but let's give it a go. So we have this visual aid, which we use to explain data protection law. It's using global terminology. I'll give you the South African terminology, considering so many of you are South African. And the way the mapper works is you work through 3 steps. And we find this a much better way to practically apply data protection to your activities as a legal practice. So the first is we need to know some facts. And things like, well, what personal information do you have? And you've got lots of personal information, as we've been discussing. But for example, if we look over here, you're going to have a lot of financial information. You're going to have extensive personal information about people. In terms of conveyancing, there's lots of personal information that you would have there. You might well have a lot of information about criminal behavior and also children's information. You might also have health-related information in the context of road accident fund claims. There really is going to be a lot of personal information that you have. So the next step is going to be, who are the role players? So who are the data subjects in the context of a legal practice? And this is the person to whom the information relates. So it would be your clients, it's your client representatives, it's people who you want to be your clients. It might be other counterparties in litigation. Those are all examples of data subjects. Then you've got the controller, and in South Africa, it's called a responsible party. And that's whoever determines why and how to process. And the third role player is the processor. It's somebody who processes personal information on behalf of a controller. And in South Africa, they're called an operator. Now, what's really interesting here in the context of legal practice is that most legal practitioners think they're a processor. The client is the controller, and the data subject might be whoever it is. But that's actually not the case. Legal practices are almost always a controller. You are not your client's processor, except where you really are processing personal information for your client. So for example, if a client gave you a spreadsheet or a database of debtors and asked you to clean the data or to augment the data, then you would be a processor. But in virtually every other case, you are the controller. And Shamar's written this wonderful article here, which is on our website. And Shamar, maybe you can post the link into the chat, explaining why law firms are mostly controllers rather than processors. Shamar, anything you'd like to add on this?
I thought it was a really interesting piece of article, and the different organizations explain this really well. They provide different scenarios in terms of when law firms are considered as controllers. And I think especially in the context of legal advice and knowing your role in it.
Shamar, I think we've lost your audio there, but I'll come back to you a bit later then. Yeah, I mean, it's a fascinating discussion, and it's so important because this really is what a lot of things hinge off when it comes to data protection. Because if we are the controller, not the processor, it means we don't need to sign data processing agreements with our clients. And that's a massive issue, and it means that there's a significant change into the amount of work that we need to do. All right, so the other point here is that if we, the legal practice, is the controller, then often we're going to have lots of processors who might be someone to whom we've outsourced payroll, or it could be various internet service providers, or like a Microsoft, or a Google, or various different people. But Mark, I see you had your hand up.
Yes, John, I just want to raise a practical point relating to the controller relationship, and that is that in many instances, we will have controllers, for instance, banks, who will be requiring of the conveyances that they enter into agreements. And even if these are not necessarily data protection agreements, one of the things that they will be requiring is certain levels of security that you have in place in using that information. Because obviously in a lot of instances, even if for instance, if you go to a bank and you obtain a loan, the bank will then require the attorney to register a bond to secure that loan. And it may well be that, well, not may well be, in many instances, you get lots of information, including financial information. So while I absolutely agree with John that you don't necessarily have to be the data processor, but you are still going to be in a position in this modern world where you will be required to comply with those security issues, which very often are the crux of what those data protection agreements are about. So, you know, and for many smaller practitioners, you're simply not going to argue with the bank about the agreement and whether that they're correct in having those requirements. But I think that John is absolutely correct. But just bear that in mind, that from a practical perspective, most of what you need to do in any event as a process of this information, whether you're a controller or an operator, or a responsible party rather, and an operator, the banks are going to require, or other entities that you do work for will require, that you actually give the necessary assurances that you're processing that information safely. Thanks, John.
Yeah, Mark, I 100% agree. It's the bank could be a responsible party, and the legal practice is a responsible party, and responsible parties are only going to want to deal with other responsible parties who also secure it, and so it's very important. Shamar, you've got your hand up?
Sure, I hope you can hear me now. So on this topic, I think it's really important to for organizations, especially law firms, to know the role that they play when they're dealing with clients. And on this topic, there were two related questions that came through in the chat. Valerie asked, should companies enter into operator agreements with law firms? And then Anonymous also asked, what is the capacity of, I think she means, debt collecting agents when they are engaged by a law firm? I have shared a link to the post where you can read up about these scenarios in more detail.
Yeah, I mean, those are great questions. So we talk about a data processing agreement. One kind of that is an operator agreement. They're often called operator agreements in a South African context, but globally and in South Africa, we believe data processing agreement is the better term. But the short answer is, if you are a legal practice and you are not the operator for your client who's the responsible party, you don't need to sign a data processing agreement. Your client might still want you to sign some form of agreement, but the law doesn't require there to be an agreement in place. On the second component with the debt collection agency, there, I think they probably are an operator for the law firm or the legal practice as the responsible party. And also picking up on Viv's point with correspondent work, that's an interesting one, and I'm not sure. Again, it's data protection is principle based. So all it tells us is that whoever determines why and how to process personal information is the responsible party. You can have joint responsible parties, and sometimes you have one party determining why and the other determining how. So it can be really tricky, and we need to look at each one. But I'm not sure about correspondent work. That would be an interesting one. All right, let's keep going, and I'm going to share my screen. Yeah, but thanks very much for your comments and questions. It's really good to have them coming through. So that's a really important point that we need to tackle with. The next points to make are that data subjects have certain rights. They have a right to know what you're processing. They have a right to access their personal information, to ask you to change it. It's an important thing to give effect to. Then controllers and processors have some obligations. And the main thing is that there are some data protection principles that apply whenever you're processing personal information. So that is the essence of data protection, and really is a very quick overview of some important things for legal practitioners. I think I'll quickly pop to this as the last slide. This sets out the 6 main principles. And so controllers or responsible parties must process personal information lawfully, fairly, and transparently. So note it's fairly and transparently. So we need to be open about what we're doing with people's personal information. We must process for a purpose, only as we need to for that purpose. We must have accurate personal information. We must keep it for no longer than is necessary, and we must secure it. And Mark's already touched on the security component. I'm going to come back to that in more detail because that's a very important component of this for legal practices. All right, so the other thing under this step to quickly touch on, the risks are really significant for us. We're going to lose clients if they don't trust us with their information. We could get fined by an authority. In South Africa, it's up to 10 million rand. It's very unlikely anyone will go to jail. And we might have to pay damages to clients or to data subjects. But a good example here, which happens a lot, and I'm going to see if I can find, no, I don't think I'm going to be able to find the example that I thought of here. No, that's not it either. Sorry, I might, actually, this looks like, sorry, no, that's not it either. Sorry, I'm losing the place here. But really, what the example is, it's been in the press a lot, and you would have seen cases, it's called business email compromises, or it's just good old plain fraud. Basically, a cyber criminal manages to get hold of personal information, like they get to know that there's a property transfer happening. And the one example that I wanted to show you is, and this actually happened with me, a young couple called me and said this had happened to them and asked for my assistance. Basically, they had bought the house of their dreams, signed the offer, and they were over the moon. They then got an email from the conveyancer saying, I referred to the sale agreement, I referred to the clause saying that you must pay a 10% deposit, please pay this into an account. And the couple then, it was, the email was from the law firm, everything was perfect. They paid the money into the account, and it actually wasn't the attorney's account, it was a criminal's account, and they lost their money. And they wanted to try and hold somebody accountable for that. And that's a scenario where the criminal spoofed the legal practices email address, pretended to be them, and got somebody to pay money across. But this scenario also happens in many contexts where the law firm pays the wrong person out. A criminal convinces them that they are the client, and the law firm then pays the money to the criminal rather than the client. And this happens a lot, and the risks here are significant, because it could be that you end up paying out 5 million rand, for example, to a criminal, and you're going to have to then pay your client that money, and you might be insured, but you might not be. And I know, Mark, this is an area you've done a lot of work in, and I don't know if you want to add to that in terms of the risks associated here.
Oh, thanks, John. I have done a lot of work, and I can assure you that, that this is a crime which is significantly on the increase. And I'm dealing with a matter at the moment, or I'm involved in a matter at the moment, where the amount is 5.5 million rand that was paid into the incorrect bank account. And one of the things that is very, very important here is that this risk has been known for some time. In risk alert from the law professions insurance indemnity fund, there's been a lot written about it, and the losses are significant. They run into hundreds of millions of rand, both from the point of view of practitioners and clients. And just remember that in a lot of cases, possibly you acting, for instance, for a seller, but a purchaser pays into the incorrect bank account, and the result is that sale falls through. And I've not had to deal with what the sellers in those instances before, but I have in one instance a seller has spoken to me about it. As it turned out, the matter was resolved. But the seller spoke to me about it, and he said, look, they're my attorneys, but if they've messed up and I've lost this deal, it's not actually just the deal. There's a whole lot of other consequential damages about it. As I say, thankfully that was sorted out. But the attorney was exposed to significant risk. And one of the things, if you look at the cases, there's a case called Jurgens and Volskink in Eastern Cape, and another Fourie versus Van der Spey. The former was the latter was in Gauteng. And in both cases, the judges referred to a judgment many, many years ago by our Chief Justice at the time, Lord de Villiers, who said that we have to be particularly careful. And as attorneys, in dealing with what we are dealing with, we have to show the skill that is necessary. So one of the things that I think is important here, and it isn't case law specifically in point, but even where it is not your client, where you have asked somebody to pay an amount into an account, and that is spoofed against the background knowledge, is the use of email, which is notoriously insecure. Are you not being negligent in doing that? And in fact, Judge Matthew Klein had quite a bit to say about that. It wasn't necessarily part of his judgment at the end of the day, but how important it is that we are actually aware of these risks and that we take measures against them to ensure that clients and others are not damaged. So I do suggest that we look very, very carefully at the security that we have, because in some cases it's just personal information, and that is used to masquerade as somebody else. But in other cases, it is used not just to masquerade as somebody else, possibly to masquerade as you, as the firm of attorneys, because these are very sophisticated crimes. I promise you, it will look identical to your letterhead. It will look identical to the email that you've sent out to the client, in every respect that there might be a minor change in the email address, and suddenly you're paying, or your clients, or possibly not even your clients, but purchasers in the case of conveyancing, are paying money into the wrong account. And in my view, in today's age, that risk has been around for a while, at least 6-7 years, and conveyancers that are not ensuring that there is proper security around their communications, which contain personal information and business information, are being negligent. Thanks, John.
Thanks, Mark. And maybe just to pick up on that, in the handout that we'll be sending you, we have included some useful resources. So you'll see down here at the bottom of the handout, there are various useful resources. And two that we've given you, the one is Private Property have some really good information about property-related scams and how they work and what they look like. And so, for example, here, they actually go into don't interact with the following people. So if you get emails from those people, these are the emails, the wording of the mails. So you can read what the standard scams look like and make sure you don't fall victim to it. The LPIF has also got information about it that will help you as well. All right, so let's move on to the next step. I'm just conscious of time, and that is the plan step. So we've raised some awareness. We're now getting into, okay, what are we actually going to do about this? And for us, these are the steps that you need to take in planning. And you don't need to brief your governing body. It's as a legal practice, you probably, and most of you are small enough that you don't have one. From a perspective of getting governance right, you don't need a data protection officer, particularly most of you are South African. But what really is very important is the role of the information officer. The key thing here is that all of you have one by default. You can't avoid it. And the person who is by default is the head of the legal practice. So that would be, if you're a sole practitioner, it would be you. If you are an Inc., then it would be one of the directors, and potentially if one of those directors is the managing director or is the practice manager or the lead, then that person would be the default. If you're a partnership and there are 3 or 4 partners, it could be any one of you, and really you should decide which one of you is going to be that person, because they have quite significant responsibilities, both under PAIA. There's the various things there, including relating to the manual. And then under PAPIA, they also have various responsibilities. So you need to make it clear who is actually responsible in your legal practice for these issues. And then you need to register them with the information regulator. Their portal, unfortunately, is down and has many bugs. So many people are waiting for the portal to be fixed before they register their information officer. You can do it manually, but I think that their mailboxes are pretty full, and that's not ideal. It would be much better to do it straight into their portal so that the data is in their system, as opposed to somebody having to then go and manually input the data into their system. Then there's training relating to the information officer. We offer training for the information officer. And it would be important that that person knows more about what they're seeking to achieve. So that's really, from a governance perspective, the important thing. Few law firms or legal practices require software, although that's an option, and particularly for the larger ones of you, you might want it. Mapping activities is important and doing a gap analysis, but that's not something to be undertaken lightly. Particularly if you wanted to map all your activities as a law firm, it's a significant undertaking. And so we often suggest to people, focus on some quick wins and focus on some actions to take first. And particularly for those of you who are smaller legal practices, that's what I would suggest. And so what we thought we'd do is go through some of those quick wins in the next sort of 10 minutes that we've got available now. They are in the handout if we look here. So here's the plan step, and we go into more detail of what I've just covered really quickly there. And so we're going into the protect step. And the first thing that I wanted to talk a bit more about was information security and talk about some quick wins there. So the first one is, in terms of quick wins, is that everybody should be using a password manager. Now, I don't know, maybe you can pop in the chat whether you do currently use a password manager, but this will change your life. It seriously will. There's one called 1Password, and then there's another one called LastPass. And there's a free version and then the paid for version. But a password manager, it saves all your login details for you. And then it puts a little plugin in the browser that enables you to quickly access them and autofill them when you need to. We don't recommend that you use Google's password manager. Apple's password manager is not bad, but I prefer to have something that's independent. So I use 1Password. So I've got to remember 1Password, which unlocks my vault, and that gives me access to all my logins. I've got about 400 logins, and I've got very long, very secure passwords, and they're unique for every single thing I access. And often passwords is the weakest link. And so everyone in your practice should be using a password manager. Absolutely critical. And if you don't take anything else out of today, for me, this is the most important thing to take from today. Then it's really important to shred any personal information in physical documents that's being thrown away. We're trying to stop identity theft, and using shredders is part of achieving that. Focus also on physical security. If you've got lots of paper records, it's very important that they're in filing cabinets that are locked, preferably in rooms that are locked as well, and you control access to that. Definitely encrypt your devices, and both in terms of your communications and your drives. But I just wanted to mention that Windows comes with BitLocker, so you can encrypt any PC, and Macs come with File Vault. There's no additional cost. You don't need to pay more, and you can encrypt your computers and your laptops. Definitely worth doing. Actually, while I'm here, also to mention, it's really important that you implement SSL or the little lock that you'll see in your browser. So you'll see it there. If I go across here to Michalsons' site, there's the little lock. That's SSL, and you should implement SSL on your website. And if we zoom back out of there, the last thing is backups. It's really important that you make sure your backups are secure. We've seen some horror stories that relate to this. And Michelle, I don't know if you want to add anything in this context.
Oh, apologies. Yes, John. I think, when you do backups, it's important to ask yourself certain questions just to ascertain how secure your backup is. You need to ask the question, where is the service stored? How is the data actually being backed up? And also, are the backups encrypted? And while I have a chance to talk, I see Stuart asked a question with regard to security. I asked a question on CCTV monitoring, and I'm just quickly going to touch on it. As far as I know, it's not regulated in South Africa. And it's also not a requirement under PAPIA to install CCTV cameras. But if you do, it's important just to know that those images that you are capturing would then need to be protected under PAPIA, because they would be regarded as personal information. And with regards to audio recordings, if you're going to have the cameras and there are audio files on it, then that would be protected under RICA. So that, but I see Shamar did post a link to an article that we wrote on CCTV monitoring.
Yeah, maybe should we go to Shamar?
Yes, just to add to what Michelle said, Michelle mentioned earlier, some other simple tasks that you can take to secure information. And I see Deepak asked a question around FICA and is there any changes in the FICA laws that stipulate how documents should be stored to ensure compliance? I don't know if anybody wants to answer that one.
Yes, it's a really interesting one. Mark, your hand's up. Do you want to answer first?
I put my hand up to answer something else, John.
Oh, did you? Okay.
So you answer that one, and I'll just raise the other issue that I think is an important quick win.
Perfect. So FICA, it's an interesting one. It's required us as accountable institutions to verify people's identity and gather vast amounts of personal information to do so. I almost see FICA as one of the biggest threats to privacy and to the protection of personal information. So FICA doesn't go into a lot of detail of how you must secure it. It's actually PAPIA is the law that requires information security and sets out the level that you need to achieve and how you need to achieve it. So PAPIA is the law that says you must secure information, and that's a really big change that happened on 1 July in South Africa. There's now a legal obligation on you to secure it in terms of PAPIA. Yeah, but Mark, back to you in terms of the issue you wanted to raise.
Just one of the things we must recognize, as John has just said, PAPIA actually sets out, and it's the first instance in our law that statutorily requires information security to be put into place. And what it says is that you need to put into place the appropriate technical and organizational measures. So part of what I really believe is important here is that many of our breaches occur not as a result of malice, but as a result of ignorance, people doing the wrong thing because they don't understand it. And that's part of your organizational measures, making sure that people within your organization know the importance of what they are processing, and that they have that you've equipped them with the right skills to use, for instance, encryption, passwords, etc. Passwords we use a lot, but nobody really explains very often to people how important it is that that password is secret. That's the key to a password. It doesn't matter how strong it is. If it's not secret, that's a problem. So those are areas that I believe there is a cost. Obviously, training is costly, but at the end of the day, training is a lot less costly than ignorance. And the other thing about it is that, remember, in the world that we're living in, if we are training people within our business to do the things properly, part of what we are doing is we're also equipping them with the life skills they need, because information security doesn't go out the door when you walk out of your business. In fact, it's there all the time, whatever you are doing. And very often people's private lives and their business lives are intertwined. So I think that that's a very important aspect of information security that is often neglected. We'll have policies in place, we'll have encryption in place, but we haven't trained people correctly. And that's a critical thing.
Thanks, Mark. I totally agree with you. And it's one of the items we address is that you have to raise, because today we obviously can't cover information security. You've got to raise your level of awareness around it, and then all your employees in your legal practice. And there's some really great public materials that are available publicly that you can look at, and they're for free. And maybe let me show you some of those quickly. So in the handout we're going to be sending you, here are the useful resources, and here under information security are some really good things. This over here, this summary is from the ICO in the UK. And it's basically a summary of the incidents that solicitors and barristers have had. So this is the issues that they face. They lose or paperwork gets stolen. They post or email or fax to the incorrect person. An unencrypted device gets stolen. An email gets sent to the wrong person. Insecure disposal of paperwork. So that's fantastic. You can learn from this and see where the big issues are and then focus on getting those right. And then this is a great example. This is a cybersecurity guide for lawyers that's in Australia. And here they go into a lot of detail of, well, these are the different things that you can do. And so with EFTs, do that. Security measures, do this. For client information, do this. And you can tick it off like a checklist. So there's some really good stuff there. There's also this document over here, which is the document that Mark wrote. So this is protection of personal information for South African law firms. And this goes into a lot of detail on many issues. And so there's lots of good material there that you can read and work through. Yeah, so those are two of the important things that we were going to tackle here under quick wins. It was around the awareness training of yourselves and your employees. It's really important to do that. You've got to raise awareness. So some of the other things, I see we're running out of time, and they're in the handout here, but one is you must protect the personal information of your employees. Don't let an employee's identity get stolen. Protect their bank details. Then you must have the correct documents in place. It's absolutely crucial. So you need a privacy policy, a cookies notice, and a policy. And I wanted to show you this page. This is the Trust Center on the Michalsons website. And this is how we've tackled it and really sets out the different documents I'm referring to here. And we've also then got information about how we tackle privacy and data protection and how we secure information at Michalsons. Yeah, so that's various things there. With that Trust Center, if you are a member of our program, I'm very happy for you to borrow from that page and adapt it for your needs. You will need to adapt it quite extensively. But if you're not a member of our program, please don't copy our Trust Center. It's it's for members only to use. Then other things, you're going to need to get cyber or data protection insurance. And in our program, we go through a lot more information about who the options are, who offers it. And a very important thing to know is that cybercrime is excluded from the indemnity cover provided by the LPIIF. Very, very important to know that. You are going to need a PIE manual. Lots of people ask us that question. Nobody will be exempt from 1 January 2021. From 1 January 2022. So I'm afraid all of you need a PIE manual, and no matter how small you are. Mark, I see your hands raised. Sorry, you're on mute, Mark.
Sorry, John, it's an older hand.
Okay. I'm glad you included the word "it" in there. So Shamar, should we go to you? Are there any related questions related to what we've been discussing?
I just had a comment in relation to what we were discussing. It was about training for employees. So in the first week of joining a company in the past, I managed a group of really young individuals. I'm mindful of the time as well. I'll try and wrap this up in a minute. But in the first week of joining, I took a walk around the floor and I saw people sticking their passwords onto their monitors with Post-it notes. They were dealing with really sensitive personal information and it was strewn all over their desks. And to tackle these issues, I think what's really important is to have open discussions with your team and with management, because it starts from the top. And we employed a policy and I called it the clean desk policy. And these are simple things that you can implement to ensure that personal information isn't lying around, and that you work with information responsibly.
Yes, yeah, no, I agree. There are many simple, very important things that can be done. All right, we're at the top of the hour. Whilst we see if there are any questions, just before we go there, I just wanted to wrap up a little bit. I know we've been a bit rushed, but we will be sending you the recording and also this handout, and you'll find various useful resources there. For further reading, for example, the Law Society of the UK's guidance and support is very good. It is relevant in a GDPR context, but it's also relevant in a South African context. It's almost 80% the same, and there's some really good stuff there that's worth looking at. So then, if you enjoyed today, you will find a lot of value from our data protection program. And this is the page which Shamar can pop into the link, which gives you more details about our program. And essentially, you would then join the large, medium, or small program, and that then gives you access to various different lenses, one of which is this lens that we've done today for legal practitioners. It's a way of looking at the content through a particular lens. So what I thought I'd do is ask a question, which is, if I'll launch a poll. So the question is, are you interested or going to join the Michalsons Data Protection Program? I'm really interested to get some feedback from you here. So if you wouldn't mind answering that, that would be great. At Michalsons, we really believe that feedback is the food of champions. We really enjoy feedback, positive or negative. And so I'm going to also pop a link into the chat, if you wouldn't mind filling in that form to give us feedback on today's session. And if you wouldn't mind completing this poll as well, that would be great. And I'll share the results with you just now. So I'll end that poll there and share the results. So many of you are saying that it looks like what you need, or that you need more information. So Shamar will pop the link into the chat box, but it is on our website. In the top right corner, it says Join Program. And you can click on there and watch a video about the program, find out a lot more about our program, and then you can join it as well on the website. So I hope that helps. And yeah, thanks very much for the rest of the feedback. I'm very pleased that 20% said that this session gave you what you needed. I'm glad that we were able to help and point you in the right direction. There is lots of information that's available. And then lastly, I think it's just to check in with Shamar. Any key questions that we should answer before we wrap up?
John, I think we've covered most of the questions that came through, but there's lots of messages coming through from participants saying thank you for the session. I would just encourage everyone to look at our website. Some of the questions that you've had, just a reminder, there's lots of content available for free. And if you need more information, you can always join our program, and I've popped the link to join a program.
Thank you very much, Shamar. Yeah, and so thank you very much, Michelle. Thank you very much, Mark. Really appreciate your input and your contribution. And thank you very much for joining, and enjoy the rest of the day and have a good weekend.
Thanks, John. Thanks, everyone. Have a good weekend.
Thanks, everyone. Bye.